Hi class, welcome back. This week we're talking about courts, and in this lecture we will be talking about the types of cases that can be in a court and how they're different. We'll talk about the power of judicial review, which is the power of the Supreme Court and lower federal courts and state courts to determine whether a law or government action is constitutional, and we'll learn how the court checks the other branches of government's power. So first, just as a recap, so far what we've learned in this course is that the legislative branch or Congress, state legislatures, make the law. The executive branch enforces or executes the law, and the judicial branch is in charge of interpreting the law. So both in concerning disputes, but also interpreting the Constitution and whether laws are in accordance with the Constitution. So what does it mean for the judicial branch to interpret the law? It means that judges and the courts settle disputes between people. They settle disputes between government branches, and they settle disputes between people and the government. Essentially, settling disputes between people would be if your neighbor is cutting down your bushes and you're upset about it. You could bring that to the court and have it settled there. Or if the Congress and president disagree on whether an action is constitutional, that would be a dispute between government branches. Also, states can sue each other. If Alabama is mad that Georgia is dumping toxic waste into their waters, then they could bring that to court. And then finally settles disputes between people and the government. For example, if you feel like you're being discriminated against unfairly or unconstitutionally, you would bring that dispute for the court to decide. There are two big basic pieces of different types of laws, and one is civil law and the other is criminal law. And you're probably at least familiar with these in passing. So civil law is the one that settles disputes between individuals, companies, or government entities in which no criminal violation is charged, so where there's no crime. Cases in civil law are often called suits or lawsuits because someone sues someone else. So there can be libel lawsuits. So we talked earlier in the semester about something like this against someone who publishes a malicious lie in writing. So as the example that was earlier in the semester, if the Silva Herald publishes something really nasty about that there was a rat or something in their food from Chili's, and Chili's ends up having to close down as a result of that because no one will go there anymore. But it turns out that the owner of Chili's can prove that the whole thing was untrue and that the reporter did it to be mean or malicious. They can bring up what's called a libel lawsuit and actually get money for that defamation or for that libel that occurred. And then alternately, a tort lawsuit is against someone who physically or emotionally harmed you or your finances. So in civil law, the plaintiffs are the person or the entity suing another person. So it would be, in this case, it would be the owner of Chili's is suing the Silva Herald and or the reporter for that malicious writing. And the defendant is the person who's being sued, and that's where the money is involved, the person who may have to pay. But there's no legal punishment attached as far as the government is going to punish you. I mean, they may force you to make your payment, but they're not going to punish you by making you pay a fine to the government or incarcerating you, imprisoning you. The only requirement is to pay monetary damages to compensate the victim. So this type of law, civil law, often gets a really bad rap, especially when people call it tort law. There's a lot of places in the United States where people are calling for tort reform. And you can think about why. Think back, maybe you were too young to even remember this, but you certainly probably have heard of it, to the case where the woman sued McDonald's for millions of dollars because she spilled hot coffee in her lab. So often that's kind of the butt of jokes that people say, oh, yeah, you can sue anybody for anything. Now they have to print caution, it's hot on the cup and all that. But in reality, this is a really important case for this woman and for tort law, because it shows how what a bad rap tort law gets, and it's kind of some of it's kind of unfair. So in reality, in the McDonald's coffee case, the woman was quite elderly, and the coffee was extraordinarily hot. It was so hot that it gave her burns all over her thighs and groin, that she had to be hospitalized and had several medical procedures before she was well again. And in fact, she was never all the way totally well. And she brought the case to court and argued that there's no reason McDonald's should be passing like lava hot coffee through a window, through the car window, and handing it to people that maybe their hands are shaking or the lids aren't quite on enough and things like that. And so, so the court decided, when the jury decided, that McDonald's had done wrong. And so the very first thing the jury decided was that she deserved to be compensated for her medical bills. And so that amounted something in the tens of thousands of dollars. But the jury also decided McDonald's needed a worse warning than this, because think about $10,000, $20,000, even $100,000 to McDonald's is practically nothing. And so it might not change how McDonald's operates and how hot they allow their coffee to be. So the jury and the court actually gave what are called punitive damages, saying it was so bad what happened and they really shouldn't do this again, that it just shouldn't be compensation, that they should be punished. And that's where that $1 million number comes from. If you're interested in this story, there is on Netflix a show called Adam Ruins Everything, and there is a episode. I haven't seen it, but students have told me about it. There is an episode about this case, so you can feel free to watch that in your downtime while we're all quarantined. All right, so that's civil law. It's regarding money. It's people suing others for money, and it gets a really bad rap because it seems like people are greedy, but in reality, most of the time, people are just trying to be compensated for their harm. This is opposed to criminal law, of course, where the plaintiff is always the government. It could be the county government, the state government, or the federal government. It depends which law you broke and who's prosecuting you. And the defendant is always the person accused of the crime. This is entirely different. And then what comes out of this is a legal punishment that the government enforces, and it could be, anything from a fine, community service, to, of course, imprisonment. So let's talk a little bit about court procedure. In deciding cases, courts apply what are called statutes. These are just laws, but in the court system and in legalese, they're called statutes. So it's important that you know what that word means. And they apply legal precedents, which means prior decisions. Precedents are decided based on the legal doctrine of stare decisis, and that is just a Latin term for let the decision stand. So what courts are in charge of doing is not only applying statutes and laws, but also looking back in case law and seeing how other very similar cases were decided and deciding this next case the same way. And this is a way of getting a body of legal laws or legal decisions called precedents, so that people, lawyers and clients and just individuals and citizens can have an idea of how this new law is going to be passed, because we can look at it in light of other laws. Or we can think about, will this discrimination case end up for the defendant, the person who is accused of discriminating, or for the person who is discriminated against? We can look back to previous case law and see who's probably going to be the winner and the loser. So it gives stability to the entire system. There are two different kinds of what we call jurisdiction, meaning what kinds of cases the court can hear. And these are called appellate and original. Original jurisdiction is mostly occurring at the trial court or civil court, where it's the first time the case is being heard, and the very first court that the case goes to is said to have original jurisdiction. But most courts in the United States also have appellate jurisdiction, meaning that you can appeal cases to a higher court. This is not where you would decide whether somebody is guilty or not guilty, or decide how much money somebody should get on the first run. And there aren't juries here. This is where the appellate jurisdiction is where a judge is listening to a case of somebody saying that the law was not applied fairly or they were not treated correctly. So if a criminal defendant gets convicted of, let's say drunk driving or something, and they want to say, well, actually, I didn't have adequate counsel. My counsel had too many cases, or, they were drinking all day, or they never showed up to court, and they can go and say, this conviction wasn't fair. I didn't have a good enough lawyer. And the case can be overturned, and they will, the appellate jurisdiction can overturn lower cases or go ahead and confirm them and say, no, that was fair legal counsel, and you're going to remain in jail. The Supreme Court is the highest appeals court in the United States, and the Supreme Court, of course, can overturn laws not only for when people have been treated unfairly, but they can say maybe a whole law is unconstitutional. And other lower courts can do this as well, but the Supreme Court is the final say. Once you appeal to the Supreme Court, whatever they say, that's their decision. There's nowhere else you can go for to appeal it again. So as I mentioned before, the courts have the power of judicial review, meaning that upon appeal, if an appellant, the person making the appeal, says that a law is unconstitutional, or that they have been the victim of some kind of unconstitutional government behavior, the courts have the power of judicial review. They can say whether the law is constitutional or unconstitutional. And I have a quick crash course video for you to watch that explains it in more detail. All right, hopefully that recording worked. If it didn't, I'll give you some other instructions. So that is the power of judicial review in a nutshell. It's a complicated process, but essentially it's just the ability of appellate courts to overturn laws or government actions or even previous cases as unconstitutional. So the video mentioned that the court gave itself the power of judicial review, and that is fundamentally true. That the court in Marbury versus Madison said that it is the job of the Supreme Court and other courts to say what the law is and what the Constitution says. But this really does come from the foundation of having a constitutional democracy, and particularly from the Supremacy Clause, which states that laws passed by the national government, all treaties, are supreme law of the land and superior to all laws adopted by any state or any subdivision. And it also is that the Constitution is superior to all laws that are passed by Congress or anybody else. And fundamentally, if the courts or no branch could say what the Constitution says and what its limits are, then there would be no point in having a constitution. If it was up to Congress to say what laws are constitutional, they'd say, well, whatever we're passing that day. Or if it was up to the president to say what executive actions are constitutional, the president would always say, of course they're constitutional, or else I wouldn't be doing it. And so it really takes a third branch to be able to be a check on these powers. And so they can strike down things like congressional laws, executive orders, bureaucratic rules, and other courts' decisions. The Supreme Court, again, is the highest court you can appeal to. And so once it has made a decision about constitutionality, it is binding on other branches of government and lower courts. Only the Supreme Court later, in a decision that maybe overturns previous decisions, or a constitutional amendment, can nullify a Supreme Court decision. And this does not happen very often. So one very famous example of a Supreme Court case being overturned by a future Supreme Court is when Plessy versus Ferguson was later overturned by Brown versus Board. More on that next week, a few weeks from now, when we talk about civil rights. And then also, similarly, rarely, a constitutional amendment can nullify the Supreme Court decision, which we know from previous weeks that there are only 27 constitutional amendments, and 10 of them were passed in 1791. So they are not usually going to be overturning Supreme Court decisions either. The Supreme Court is, again, a check on other branches. And the video sort of talked about detainees, but also about executive privilege, which in the case of Nixon, the Congress said, turn over all your tapes, we're doing an investigation as part of the impeachment process. And Nixon said, yeah, no, these are important to national security, I'm not turning them over. And so the case, because it was a dispute between Congress and the president, went to the Supreme Court. And this is the Supreme Court in this case held in favor of Congress and said, this is a serious crime. There seems to be evidence that there was a crime committed and that these tapes could show that. And really the reason you're keeping the tapes is in order to cover up that crime, part of a systematic cover-up. And so the Supreme Court very rarely enters into disputes between Congress and the president, but sometimes they have to. One thing the court does even more rarely is when Congress actually just hands the president power. Usually the Supreme Court does not step in and say no. But one important case, this happened in 1996, Congress passed a law that it would allow the president to mark out provisions of bills before signing them into law. So just take out pieces that the president didn't like, maybe take out pieces that gave money to things the president didn't want. And the court determined this to be an unconstitutional delegation of legislative authority. In less legalese, it meant the Congress gave the president part of the Congress's power, the power to pass laws. If Congress, all 535 of them, are going to do this dirty work of writing legislation and making compromises, and the president, when it gets to his desk, can just mark it all out, there's not really a limit on the president. and what he can do concerning what kind of laws he can pass. Because the president could just whisper into his party's ear, oh, don't worry about that, I'll mark it out later. And there wouldn't really be a check on the president's ability to do that. So that's all I have for this lecture about sort of court procedures and limitations on power and the role of the court. I'll have another PowerPoint in which I will talk about the road to the Supreme Court. That will talk more about what appellate jurisdiction is, how a case gets to the Supreme Court, and then finally, how the Supreme Court decides cases. I hope you're all doing well.